Good morning to everyone. I see everyone is ready. Yes, Professor Aruma is ready too as well. Good. So we can start. We were yesterday in the course of the cross-examination of Professor Aruma. Can we start with continuation of the cross, or is there anything that the claimants or the respondent would like to raise in advance?
Yes, there is a very small housekeeping point, and my colleague, Ms. Jardine, has just sent to the tribunal and obviously the other side an email with updated appendices to Ms. Wall's expert report. So while preparing for today's cross-examination, Ms. Wall has realized that two figures in one of the appendices were wrong, and that had an immaterial effect on the total damages that she calculated. They are smaller by, I think, 100,000 or something like that. But just in the interest of full transparency and being correct, she wanted to correct that that mistake that she made, and she can explain it later today what it is. But to give everyone advance warning, we have sent this now. As I said, the total impact is negligible.
The secretary says she has not received it, and I have not checked my messages yet.
So it might still be in transit.
Good. Yes, indeed, it's not yet arrived, so maybe will. And the respondent will have a chance, of course, to look at it, and you can ask Mr. Mwangakala to also look at it, so when he has seen it in advance.
Madam President, I'm not sure if that is in the procedural order, and I'm not sure if...
Yeah, it's not in the procedural order as such, but it could happen that in the direct presentation, the expert could make a correction. That's part of the direct examination, is a correction to the expert report or the witness statement. And I understand she's making this in advance so we can all have a look at it rather than to have to react on the spot. So
until we see it, because we have not formally received it, but normally I think they are supposed to make formal application and then introduce that thing. But otherwise, then we'll have to look at it and then we'll make appropriate application formally.
So I think that's fine. Why don't you wait for receiving it, and then you look at it during a break and you come back and say whatever you want to say.
Yes.
We still have the continuation of Professor Aruma, then we have Mr. Genge, so we have time until we get to the examination of
Madam President,
Mrs.
no
Wall.
problem, no problem.
Good. Fine. If that's fine like this, then we can proceed with the cross-examination of Professor Aruma. Mr. Forden, can you continue with your questions, please?
Thank you, Madam President. Good morning, Professor Aruma. Now, Professor Aruma, you were the Chief Executive Officer of the Geological Survey of Tanzania in the years 2013 and 2014, correct?
Correct.
And so in that role, you evaluated and opined on the claimant's applications for retention licenses, didn't you?
No application were submitted to the commissioner.
So you're telling me that in your role as the CEO of the GST, you did not review those applications?
No.
No. Well, the government of Tanzania says expressly that you did. Let's take a look at the rejoinder, which is,
Can I just, I'm sorry to interrupt, but I don't get the transcript. I don't know whether others do get it.
I'm giving it. Let me swap it out. I have another one.
Apologies, Professor Muruma, but it's better if we can get the transcript.
Do you want to use mine for now?
Yeah, maybe.
Oh my goodness.
It's just blank. Thank you. Yeah.
Thanks, Dave.
Where is the? Oh, yeah.
Okay.
Thank you very much.
Just 1 second. I'm ready.
Fine. David, are we all set?
I am ready. Thank
Good.
thank you. So if we look at paragraph 48 of the rejoinder, the respondent's rejoinder, it's at tab 12, Professor Aruma. And there's some highlighted language there. And it says, practical reports which were submitted under section 37(2) of the Mining Act, which is the section that deals with retention licenses, during the application of the retention license were submitted to the GST for technical evaluation and opinion. So can we just agree then, sir, that that was part of the process? When a retention license application was made, it was sent to the GST for review and analysis?
This is what is written here.
Do you disagree with what the government of Tanzania says?
No, I agree with it, but it was for
Okay, you agree with
for
it.
technical review, but decisions would be drawn by the commissioner.
But let's read on then, because it says, by the time the claimant applied for the retention license, Professor Aruma was the CEO of GST, and therefore had an opportunity to evaluate and opine on the claimant's application for retention license, and therefore you're aware of the provisions of the law. So the government of Tanzania says that you had the opportunity to review and opine them. Are you saying that the government is wrong?
The government is right, but they are reviewed on it on behalf of the mines commissioner.
So
So
if the government is
provided my technical advice to the commissioner for his decision, so he is responsible.
So if the government is right there, that means that you took part in the approval of those license applications, didn't you?
I advised them.
You advised them, and you advised them to approve them, didn't you? I need a verbal answer, sir.
Sorry?
I need a verbal answer.
Oh, yes.
Yes, you did. So in 2013 and 14, it was your view that they met the technical requirements for a retention license. But fast forward to 2020 and 21, and all of a sudden they don't meet the requirements. Isn't that right?
We were lenient to investors at that time.
Oh, so you weren't lenient to investors in 2021, but in 2013 and 14, you were much more permissive.
I'm telling the truth.
Okay. And those applications were also reviewed by the Mining Advisory Board pursuant to Section 37(3) of the Mining Act 2010, correct?
Correct.
And that Mining Advisory Board was comprised of members of the Ministry of Finance, the Ministry of Environmental Protection, the Lands Ministry, a senior state attorney, an academic like yourself, and someone from the Tanzanian Chamber of Minerals and a mining expert. Isn't that correct?
That's correct.
And they all evaluated those applications in 2013 and 14 and approved them, didn't they?
Yes.
And let's look at tab C9, which is exhibit C, tab 14, which is exhibit C9. Now, it's on the screen as well, Professor Aruma.
Yeah, that's better.
This is just one of the retention licenses. And do you see that it was approved by Professor Sospidir Mahongo? Do you
Yes.
see that? Yeah. And he was the Minister for Energy and Minerals, correct?
Correct.
And he was a trained geologist, wasn't he?
Yes.
In fact, he was one of your fellow faculty members in the geology department at the University of Dar es Salaam, correct?
Correct.
So he must have really known what he was doing with that extensive geological experience when he was at the ministry. Wouldn't you agree?
I agree. He knew.
And he's still a current member of parliament in Tanzania, correct?
Yes.
But he's not, to your knowledge, a witness in these proceedings, is he?
He's not.
So, is it your evidence, based on what you say in your first and second witness statements, that this sitting member of parliament, who's a trained geologist, and the entire mining advisory board mistakenly approved the retention licenses?
Not mistakenly, but they didn't meet requirements.
I'm sorry, could you say that answer again?
Not mistakenly, but the application didn't meet requirements. The approval was based on leniency.
But, sir, is that what your lawyers told you to say?
Why? No.
So,
I'm
All
telling
of
you
these-
what I know.
all of these people, including yourself, got it wrong in 2013 and 2014. Is that what you're telling this tribunal?
No, I'm saying we knew, but we wanted to encourage investment.
But you're not going to tell this tribunal that their approval was somehow invalid, are you?
It was approved, so it's not valid. It is valid.
Just one moment. Now, I'd like to go back to the PEA, which is Exhibit C100, and it's at tab 9. And again, for the record, we're
Tab
just
9.
looking at an excerpt.
Okay.
Now, I want to look at the executive summary, which is page 12 in the PDF. And specifically, I want to look at page Roman numeral 7, VII. So this is the mineral resource estimate that's been certified under NI 43-101. Do you see that, Professor Aruma?
You said which page? Yeah, now I can see it.
Okay. I think it's probably easiest if we just stick to the screen.
Yeah.
So if you look at the left-hand column, it applies different cutoff grades of gold to arrive at estimates of measured, indicated, and inferred resources, correct?
Correct.
And the resource estimate's going to go up or down depending on what grade of gold you cut off the estimate at, correct?
I haven't made a reassessment, but this is what is it's there.
My question, Professor Aruma, is more
Yeah.
just a basic sort of geological question, mine planning question. If you change the cutoff grade, the volumes will go up and down, correct?
Precisely.
Okay. So if Golder used a higher cutoff grade of 0.5 grams per ton of gold in 2010, then the 0.3 cutoff grade used at the top of this table in SRK, they're going to come to different estimates of resources, correct?
Precisely.
And then if Snowden, who later, I believe in 2015, did an NI 43-101 report, and it applied a different cutoff grade than SRK, they are also going to come to different measurements of resources, correct?
Correct.
But that doesn't mean that the overall amount of resources is heterogeneous. It's just that different competent persons looked at it under different economic constraints and cutoff grades and came to different conclusions, correct?
Correct.
And, sir, you're aware that the Snowden report came after the claimant applied for retention licenses, correct?
Correct.
Now, I want to take you through some of your criticisms of the mineral resource estimates, but before I do, I just want to make sure you and I can agree on something. And that agreement is, we're agreed, right, that the client's damages my client's damages calculation is not in any way premised on the amount of mineral resources at the SMA project. Do you understand that?
That is for the assessors.
But
Damages, I am sticking to geology.
But that's not really correct, sir. Because if we look at paragraph 32 of your first witness statement, you say, the claimant's allegation on the value of the project based on the SRK PEA is erroneous and highly fragmented, inaccurate, and uncertain. So you are commenting on the value of the project, aren't you?
PEA, values indicated in PEA are based on the content of minerals in the ground. They were making evaluation on the basis of the discovered minerals.
Well, the SRK report is making that valuation based on the mineral estimates and other factors, but that is not what the claimant's case is here. Their damages calculation is based on historical costs. Are you aware of that, Professor Aruma?
I'm not aware of that. My responsibility was to assess estimates in PEA.
Okay,
And this is what I commented here.
so this is just another area where the lawyers have inserted in your witness statement this point that you're commenting on the claimant's allegations of value, correct?
My para 32 clearly states that I'm referring to the economic assessment done by SRK in the production of PEA, which is based on the quantities of identified minerals.
Well, sir, what I'm...
Compensation is something else totally.
I'm just trying to figure out why you would spend so much time and 2 witness statements discussing mineral estimates if they weren't relevant to the quantification of damages.
As a geoscientist, my responsibility was to assess geological procedures that were undertaken by the company to prove occurrences of minerals in the ground. So the precisionness of the evaluation of quantities of minerals in the ground.
Well,
But
clearly,
the costs for doing those, they are totally away from my responsibility.
well, we've already agreed that the retention licenses were granted validly, Professor Aruma. So the mineral estimates aren't relevant to the approval of the retention licenses, are they?
Sorry, I didn't get it. I'm sorry, I didn't get it. Proper.
You and I agreed this morning
Yeah.
that the retention licenses were granted validly. So the mineral estimates that you criticize in your witness statements aren't relevant to the approval of the retention licenses, correct?
We knew you had not reached that level as per the actual requirements of the retention license, but we were sympathetic, and now.
Okay. And you're aware that the government of Tanzania invited my client in 2021 to apply for a special mining license, right?
Precisely.
And the government wouldn't presumably have made that invitation if they thought the mineral resources at the project didn't meet the requirements for a special mining license, correct?
Maybe I did.
No, you can answer.
Yes, because when you look at the regulations of granting a special mining license. After being granted a special mining license, you are given 18 to 24 months of upgrading your resource to mineable levels. And as I said, governments are very lenient. There are rooms for further discussions. So that's why we invited you to enter into a special mining license with this understanding that you will be given enough time to upgrade your understanding of the resources. 2 years, and if you and we have done it in many companies.
So if the government thought that our client's project, my client's project, was at a stage where they could get a special mining license and then bring it into operation within 2 years, then presumably the government also thought it met the lesser requirements for a retention license. Wouldn't you agree?
That's why we granted you.
Now, at paragraphs 27 and 28 of your first witness statement, you point out that SRK, in undertaking the PEA, had identified errors. And because of that, the calculated resources, quote, can be erroneous. Now, I want to understand your statement. First of all, we're agreed that SRK is the world's leading mining consultancy, correct?
Correct.
So if SRK comes in and they see errors in a drilling database, and then my client goes back and corrects those errors, is it your evidence that the whole resource estimate can't be trusted just because there were a couple errors that got corrected?
SRK, they decided to correct those errors, but with my understanding, with my knowledge, those errors are not correctable. And in fact, I could have taken measures against that laboratory.
Well, let's look at what SRK says about whether they were correctable. If we go back to tab 9, which is C100, and we go to page 46, down at the bottom, it says, where database problems were identified. SRK notified at Helio, and corrected spreadsheets were issued. SRK is satisfied that the final version of the database issued by Helio on 20 December 2011 and used for preparing the mineral resource estimate contains no critical errors. So clearly SRK, which you just agreed is the world's leading mining consultancy, did think those errors were correctable, didn't they, Professor Aruma?
They did. But as I said,
Professor-
leniency varies.
Professor
They were
Aruma-
lenient, I'm not lenient.
Overlap, try it again.
Please, sir.
SRK were lenient to admit, to accommodate those areas. Some of us are very harsh. We cannot. We stick to principles. I was trained in Germany, and the German no is no.
So are you
Yes is yes.
is it your evidence, sir, that if someone undertakes a verification exercise and finds errors, and then those errors are corrected because of the verification exercise, the whole thing is just wrong? Is that how science works, sir?
If you look at SRK, he omitted some of the errors.
Yeah, but then they
Neglected some
corrected
of the
them.
errors.
They corrected them.
No, you didn't.
Oh, they didn't. Professor Aruma, you give the distinct impression, excuse me, I'm asking a question. You give the distinct impression that your whole role here was just to try to find errors, wasn't it?
No, but the errors are there. They are described by your.
And the world's leading consultancy, who was under potential civil and criminal penalties, said that they were corrected, didn't they?
At least he says, but I didn't see them corrected. Some of them cannot be corrected.
Well, I'm sorry, but what I read it says contains no critical errors. It doesn't say they are corrected or not. Or do you refer to another place?
If I'm allowed to mention those errors and their impact
If
in
we-
resource assessment, it's
Well, let's look at the
Unthinkable.
paragraph above, Professor Aruma. It says that the errors were minor.
they can be minor but intolerable.
So what errors did you identify when you looked at the underlying spreadsheets, Professor Aruma?
For example, very, very simple example. Negative values. You give me about this bottle and you tell me to analyze content of gold and you say it has got -5 gold. You check in my pocket whether I have cotton and you say I have -5 cotton. This is
Well, SRK discusses that as well, Professor Aruma. If we turn over to page 49, well, let's look at page 50 rather. It says, after carrying out the verification measures described above, the qualified person is confident that the database is suitable to use for mineral resource estimation. Are you saying that the qualified person got it wrong?
he was lenient. Some of us are not.
But the government of Tanzania is lenient according to you, right? So SRK can't
I'm
be?
not the government of Tanzania.
So going back to page 49, we're talking about, you take issue with mislabeling. And you say at paragraph 29 and 30 that it's very possible that the estimated resources are erroneous because of some mislabeling. But SRK says, right above the section 12.32, it says, these deviations may be occurring because the assay process at Mwanza is calibrated for lower grades. Uncertainties of this magnitude occurring at the very high grade ranges are unlikely to have a material effect on the selection of material above any reasonable choice of cutoff. So they're basically saying any of these issues with mislabeling were occurring at grades that were well above any that they would actually apply if they were to do the mineral resource estimate. Isn't that what they're saying?
This is an assumption. That's why I was saying, you know, scientists, it depends on the outlook of a person who is making the analysis. The errors are there. He's trying to justify that they are not very significant. But to my understanding, those scientific errors, I could have even charged the laboratory.
So I just want to understand, you think a company that has the world's foremost reputation for analyzing mining projects and that's operating under a Canadian statutory code for announcing mineral resource estimates for the public markets and faced legal and reputational risk was just being lenient? Is that your evidence?
I don't know how rigorous the Canadian system is, but maybe they are extremely lenient. But in my country, we wouldn't allow this type of errors.
Now, at paragraph 39 of your first witness statement, you say that it is not common practice for exploration companies to raise funds and continue to do exploration after the acquisition of a retention license. Can we agree, though, sir, that in sections 37 and 38 of the Mining Act 2010, there is no condition, no prohibition on continuing exploration activities during the pendency of a retention license? Are we agreed?
Agreed, but as far as I understand, retention licenses are issued when you have attained a level in which only minor constraints are facing the project, which includes lowering of prices of the commodity and maybe some minor technical issues, like maybe absence of communication systems. Maybe there are no good roads.
Sir, do
So,
you even know what's in section 37?
So additional exploration is not a temporary issue. Additional exploration is actually undertaking a project activity, exploration activity.
But you
So
realize...
that's why it is clearly stated that after retention license, you will apply for special mining license. After adjustment of price issues and after adjustment of
Sir, if the retention license...
minor technical issues.
If the retention license is only for minor technical issues, why does it have a 5-year term, extendable to a 10-year term? That wouldn't suggest that it's only for minor issues, does it?
I think you are aware of rate of fluctuation of world prices. It doesn't happen overnight.
No, but a really low gold price isn't a minor issue, is it?
It is a minor issue.
It's a minor issue. So you could just go ahead and build a gold mine when the gold price is in the tank.
I'm not. I think I understood Professor Aruma, and you will correct me, to say it is for economic the grounds for granting the retention license are economic constraints and minor technical issue, not minor economic constraints. The minor only qualifies the technical issues. Is that right?
Well, to be fair, I asked the client, is a gold price a minor issue? And he said it's a minor issue.
Is that what you're saying? That's not what I understood.
Maybe it should be elaborated further by lawyers. But from my understanding,
No, we understand.
from my understanding, because I'm sitting in the technical committee of the Mines Commission, it clearly states that it will be granted to a person who has done exploration to confirmatory level. But the project cannot start because of some hitches, maybe lowering of the price in the price commodity in the oil market, and some minor technical issues which are related to maybe absence of communication. Maybe there are no good roads, electricity, availability of some supplies. But all the assessment has been confirmed. So we give them time to wait for those minor constraints to be outlined. I mean, elaborate out.
So the technical
corrected.
issues are more kind of infrastructural, logistical issues, as
Please.
opposed to geological resources not being established.
Precisely,
That's
because
what you're
geological law is actually a continuation of. It means you have not proved the economically viable, not potentially viable, economically viable,
Yeah.
based on
I
miners.
apologize for the interruption.
No, it's quite all
The-
right.
The testimony now is clear.
This is very
So
clear.
I want to understand something then. If the gold price is low, how can a company go out and raise money to carry out the exploration that you say has to be pretty much completed before you apply a retention license?
I don't know there because I don't know how you raise money in the stock
Okay.
market. I thought you have your own money.
You do realize that your government specifically encouraged our client to continue exploration during the pendency of the retention license, don't you, Professor Aruma?
I don't know.
Okay, well, let's take a look at tab 17, exhibit C110,
16.
17. You can just look at the screen. If you look at the last paragraph, this is a letter from the Ministry of Energy and Minerals. Are we agreed?
Yeah, I can see the.
And
I
do
know
you
the
s-
person who wrote it.
You do know the person who wrote it.
I know the person.
Yeah. Mr. Samaje, and he's an engineer. And he says, "We hereby confirm our support to your future exploration and mining activities in our country. We're currently finalizing your application for a retention license." So Mr. Samaje is saying, we're going to finalize this application. He doesn't say it'll be approved necessarily, but we already know it was. And he's encouraging further exploration, isn't he?
Yes. But remember, you had many PLs around. So maybe he was referring to the PLs that were surrounding your retention license.
He's not talking about PLs, sir. He's talking about a retention license.
He says, we are processing your application, but knowing, and we encourage you to continue doing prospecting. That means you should not pull out of the country. It may.
Is it your position that once you get a retention license, you should just sit on it? You shouldn't do anything?
As I said, you have to try to solve the identified minor shortfalls,
But
which includes,
you need to do exploration to solve that sometimes, don't you?
no,
No?
not
So-
my understanding.
So if someone gets a retention license, they can have it for up to 10 years if it's extended. Do you think it's in Tanzania's public interest for someone to simply do nothing for that entire 10 years? Is that your position?
We give you that period so that, as you said, price issues, they take long to be corrected. That's why we.
But-
not
but
to,
that's
to
not
not,
my-
not.
That's not my question. My question is, during that 10
No
years,
more exploration. No more exploration after retention license.
so would you not agree with me that it's always in the public interest to further explore, define, and delineate mineral resources in a country? Can we at least agree that?
It is, but with,
But if
due,
you're in-
with due respect, you had a retention license and the prospecting license adjacent to it. They have got nothing to do with the retention license.
Okay,
So
so,
you could proceed with the exploration in the surrounding areas.
and just leave
It-
the other period, the retention license places completely dormant.
Precisely.
That's what you have to do?
Precisely. And you do prospecting in the surrounding areas to add up.
That's what you would
What-
tell your students at the University of Dar es Salaam?
Precisely.
Yeah. Don't explore.
And that is
leave
what
it alone.
That is what our law requires.
That's what the law. Where does it require that, sir? Where in 37 and 38 does it say do no exploration?
You know, some of these things needs not to be written, but I mean, the narrations of the requirement of retention license implies that you should not proceed with further exploration because you have discovered.
So, Professor Aruma, at paragraph 39 of your first witness statement, you say, in respect of the claimant's,
Sorry?
paragraph 39 of your first witness statement, same paragraph, you say, even quarterly progress reports of the extended exploration activities after the retention license were not submitted by the claimant to the Mining Commission as per the Mining Act. So, just quickly, you still need to put in quarterly reports of your exploration activities in respect of retention licenses, but your position is you shouldn't be conducting those exploration activities. Do you not see the contradiction there, sir?
What I'm saying here, if you claim that you are doing exploration, you should have submitted. You are not allowed to do exploration. But if at all you did it, you should have submitted those quarterly reports. You didn't.
Okay, but you don't repeat that allegation in your second witness statement, do you?
I think this is exactly what I'm saying here.
Yeah, but you put in a second witness statement, and you don't come back and discuss quarterly reports. And I want to guess why. The reason you don't discuss it in your second report,
Yeah.
witness statement, excuse me, is that because the claimant submitted onto the record some 514 quarterly reports in respect of its various licenses. That's why you didn't repeat it, right?
I didn't know that submission.
So you didn't know that we submitted over 514 of them.
No, I don't.
Did
They
you
are
even
not-
go down to Medini to look?
Why should I look? Is it my responsibility to go and search as if I'm targeting you?
Sir-
I have got so many other things to do.
Sir, you have written a witness statement with a declaration of truth saying that the claimant did not submit quarterly reports, and you're saying that you didn't go down to check?
In my first,
Yes, I know. The declaration of truth applies to that one too.
so
The declaration of truth is in your first witness statement. And I'm
I-
asking you a question. Did you go down to Medini to check, or did you just put a false statement into your witness statement?
during compilation of my first statement, I went there, I checked, I didn't get them, so that's why I wrote this. They were not there at that time, so I didn't see them.
Sir, you just told me you didn't go down to Medini to check because you were too busy.
But you're talking of a second witness statement.
No, I was talking about that sentence right there in paragraph 39. You told
I
me you
went
didn't
there,
go to Medini to check.
my friend, I went there, I checked, I didn't see them.
What day did you go down there? What was the date?
When I was writing this witness statement,
Okay. So they didn't submit any. That's your belief.
I didn't see them.
Okay, you didn't see them. Let's look at one of them. This is tab 19, exhibit C452. And we've only got an excerpt here because it runs to hundreds of pages. Now, you've never seen this document before, have you? Can you go down to the next page, please, Eden?
2016. I didn't see them.
So that's stamped by Medini, isn't it? Or sorry, the Mbeya Mining Authority, correct?
Yeah, I can see a stamp there. It's a
So-
quarter report for back fix 2016.
Did you check in Mbeya?
I checked.
You went
I
to
checked
you
in-
went to Mbeya.
No, I went. What?
You went to Mbeya to check whether my client had filed quarterly reports.
I was in the headquarters of the.
Okay. Did you ring up Mbeya and say, hey, do they have any quarterly reports? Do they file any down there?
Executives. I consulted the executives of the Mines Commission.
Exactly.
They should follow it. For me, I cannot follow it as if I'm chasing you.
But you made a categorical statement in your witness statement. You made a categorical statement that the claimant had never submitted any quarterly reports.
I didn't see them.
Okay.
When I was
Well, you're
writing
looking
the
at one
quarterly
now. Can we
reports.
agree that they submitted them? Because if we go down the screen, you'll see they're submitting 13 of them right here. Do you see that?
I didn't see them. Now I'm seeing here that
Okay.
the document is stamped. But when I was reviewing, I didn't see them. Why should I lie?
So if we turn over the page to page 2,
Page 2.
page 2 at the bottom under expenditure, this is just in respect of one license, prospecting license PL 7097/2011. And it says how much money.
Counsel, could you say that number again? I'm
Sure.
trying to find it on the screen.
That's okay. PL 7097 /2011. And you'd agree with me that it explains at the bottom there how much money they had spent on that quarter drilling and exploring, correct?
Correct. You can see the numbers are there.
So you said in your first witness statement, it's unfortunate that the total funds raised and how they were spent was not spelled out by the claimant in its memorial. But you agree now, right, that the claimant was just telling the government all along how much money it was spending, weren't they?
I think we are going round and round. I didn't see these reports.
No, but you're
And
seeing
now
it
you are
now.
showing me them here. What I was supposed to do is to take them and to cross-check whether they fall, this PL, they fall in the retention license. There's a need for scrutiny. You cannot not just show me a document here and that I agree with it. Do all these licenses fall in the retention license? Those are things that needs to be verified before we can testify that they are correct
Mr.
submissions.
Ford,
I'm seeing them
indeed,
here.
I think Professor Aruma can say, I see expenditures listed there, but then he cannot verify them further.
Sorry?
He can confirm to you that he sees that there are expenditures listed in this quarterly report. Beyond that, he cannot verify anything.
With respect, Madam President, I don't think I asked him to do so.
Okay, good. So maybe he has misunderstood then what you asked him
Okay.
to do.
So let's just briefly go through this, because I believe that you said somewhere that that if there were reports, they were substandard. You said that in your witness statement, correct?
Which reports? Sorry.
Well, at one point you say there were no quarterly reports, but in a different part of your witness statement, you said that they were substandard. So I want to look at these now. even though you said you've never seen them, and you can tell me whether you think they're substandard. Okay? So if you look at the next page, after expenditure, it's got a pretty lengthy description of the work conducted. Do you see that? It's on the screen, sir.
The one that you are showing me here, they display that. But as I said, I have to, what is required is for me to take, because these are PLs. So I have to take them, check whether they fall under the retention license, and then read them properly.
So you realize, sir, that the claimant provided these 514 quarterly reports, to the respondent in July of 2022. So you've had months and months to look at them, but you still never did.
Sorry. I didn't see them, my friend. How many times should I say this? I didn't see them. I haven't seen them. This is my first time to see them here.
Professor Aruma, I just have a few more questions for you. I want you to take a look at the exhibit on the screen. It's not in the bundle. This is VW 2-3.5, and we're at page 111. And given your experience in geology and mining, I want to see if we can agree on the status of the SMP project at the time we allege it was expropriated in 2017, 18, and 19. Okay? So, Professor Aruma, would you agree with me that the project had this characterization down here at the bottom line where it says, resource has been defined, but a pre-feasibility study has not been recently completed? You would agree that the SMP project meets those characteristics, wouldn't you?
Particularly in the, you remember, much of your exploration was focused on mainly 3 targets, while you had identified several targets in the area. So this is true for particularly the 3 targets, if you remember, Genge, Genge, and the Porcupine.
Okay.
But your area was much larger.
Okay, but the core of the project meets that characterization?
At least in those 3 targets.
Okay. Thank you, Professor Aruma. I have no further questions, Madam President.
Thank you. Are there any questions in redirect? Mr. Mandepo?
Madam President, we have few of them.
Yes, please.
Professor Mruma, just to start with, my friend has asked you on the report, which you have been consistent in saying that you didn't receive them. Can you please tell the tribunal correctly what happened, briefly?
Sorry, I'm sorry.
The reports which my friend was asking you, did you receive them?
The quarterly reports.
Yes.
When during my compilation of my witnesses' statement, I went to Madini. They were submitted only 4 reports. I listed them there. They were extremely fragmented. No information at all. Because, and in fact, I described their shortfalls.
Thank you, Professor Mruma.
Professor Aruma, I'll ask a few questions to help the tribunal understand from what our colleague was asking you. The first question I'm asking you is on the tender. The council took you to the tender C11. Do you remember?
Yes.
Now, this purported tender, was it finalized to your understanding?
It was not
Yes or no?
No, it was not final.
Thank you.
Can you please specify analyzed by whom? Did you say analyzed?
No, no, no. Was it finalized?
Finalized.
Yes.
Sorry.
Yes.
Yeah.
Thank you.
Madam President, if I may, I mean, when someone says that you have to answer something yes or no, I think it meets the definition of a leading question, so perhaps council can come back to open questions.
Yeah, maybe you just don't say yes or no, you just say, was it finalized? And then Professor Aruma will say whatever he thinks is the correct answer. But to make this short now, we understood that you said that the tender was not finalized.
Sorry, Madam President, maybe if you can guide me again. So you want me to
only
repeat the
thing
question?
is just you ask the question,
Yes.
but you don't say yes or no at the end.
Okay.
That's the only
Okay.
thing.
Understood. Okay. Now, can you explain what do you know about the tender in relation to the questions that were put forward to you by the council?
From what I know, and that I might not be so precise because I'm a human being, the tenders were advertised. They were advertised, open tender, internationally. And there was a connotation there that whoever is going to win, because we were expecting that even the holders of the retention license will apply. Many of them, they didn't. And then we realized that, and there was a condition that the winner will have to sit with the holders, the previous holders, and negotiate and provide them with the appropriate compensation. But then it was realized that, or the government thought that it is better for the government to fully participate in that negotiation with two reasons. That was my understanding. It is the government who knows how much the holders of retention license have suffered in doing exploration. So we'll try to protect them as much as possible in the negotiation so that they can get appropriate compensation. And mind you, we have those quarterly reports, exploration reports, so we can provide them as a testimony of how much they have spent there. That's one. I think that was the main purpose of the government to try to participate in the negotiation. The second reason was, I think we all know, there is a possibility for a company to bring his parent company or sister company and exaggerate the amount the amount of compensation. And you have to remember that that compensation will be counted as a capex, capital expenditure of the overtaker. So there was a need to regulate that also, to see that the newcomers do not come with an exaggerated capital expenditure, which is not realistic.
Okay.
That is
Thank
for,
you.
just for, sorry, if I just can ask, that is for tax reasons?
For?
For tax reasons?
No. If you do exploration
Yes,
and I buy your properties
yes,
to continue with in mining, the amount I paid for you, I will count it as a capital
Yes,
expenditure,
yes.
and it will affect the pace of my payments of my taxations.
that's what I,
So many people, they use it to avoid
to
taxation.
reduce the income, is that what you
Income,
mean?
yeah.
And therefore reduce the taxes?
Yeah, so there was a need to control that also, to protect the previous exploration companies, but also to minimize these practices of exaggeration of amount of those transactions. That was the main, but to my understanding, that was
Thank
the
you.
reason why the government wanted to fully participate.
Thank you, that's clear. Apologies for having interrupted. You can
It's
ask the
okay.
next
It's okay,
question.
Madam President. Professor Mruma, the council also took you to Exhibit 452, which is PL number 71097/2011. Remember? I mean, quarter report.
Yes.
Remember?
Yes.
Now, is it part of the retention assets in dispute?
That's why I was saying, because it's my first time to see here, what I was supposed to do is to check whether they fall in the retention license or not. I haven't checked properly because it was going very fast. But I think because they have several PLs, prospecting licenses, out of the retention license, so some of this could be from outside.
Thank you, Madam President.
You have no further questions?
Yeah, we're finished, Madam President.
Fine. Do my colleagues have questions for Professor Mruma? You do not? Professor Mruma, you have just before explained the reasons for the removal of the tender. Now we see online. Yeah, thank you. I'm getting disturbed if I have to, if I see my face all over the room. No, you have, apologies. You have explained the reasons for the removal of the compensation condition in the tender of December 2019. And you have also said that the tender was not finalized. And I wanted to ask you why it was not finalized.
The first tender was not finalized.
The first tender,
The
one that was issued on the 20th of December 2019 without the compensation condition, that is the one that was not finalized?
The first one was with the compensation on their own. Then it was not finalized. We came up with another tender where the government would have participated in the negotiation of the compensation.
So that's the one that was issued the next day?
To the next stage, yeah.
Okay, thank you. You explained to us in your written statements and yesterday that you were chairing the investigating committee that led to the that I understand to have led to the amending legislation in 2017. Can you, and somehow I was trying to understand what the reasons were in your understanding for the amending legislation.
I'm sorry. I was, as I said, my, the team that I led, its responsibility was very simple. It had got nothing to do with the tender, with the legislation. The government, through customs, is responsible of checking authenticities of declared minerals that are declared by exporters. When they're exporting minerals, we have to check their quality and quantity and so on and so forth. So they were doing that. And abruptly, it's just a simple, abrupt measures of checkup. So we were told to check the amount of minerals in the concentrates and in the ore. That's why I'm saying it was not targeted to acacia. We checked a lot of mineral content in copper ores, in nickel ores that were being exported. So our responsibility was to take samples, analyze them, look at the content of those minerals, and report it to the government. That's all. It has got nothing to do, I don't think that it has got anything to do with the amendment of the law.
Okay. And with respect to the cancellation of the retention licenses in January 2018, what can you explain to us what the reason was for this cancellation?
I don't know really, because that is more of legal issues, and it was done by the parliament, so I don't know.
Good.
There must be some good reason there.
Let me just see whether I have other questions for you that have not been asked. We have discussed the meaning of technical constraints in section 37, so that is fine. We have discussed the finalization of the tender. No, that is all then. I have no further questions. Any questions on council's side as a result of tribunal questions? No?
No, Madam President.
Fine. Then that ends your examination, Professor Aruma. Thank you very much for your assistance.
Thank you.
Fine. It is now 11 past 10. It's a little early for a longer break. Should we just break for 5 minutes and then continue with the next witness, and we'll take a break then a little later? Is that fine? The next witness is Mr. Genge. I need to start again because we were both off microphone. You switch on your microphone by pushing the button, and then you can leave it on so you don't have to think about it. So I will say good morning.
Good morning, Madam President.
You, for the record, can you confirm to us that you're Edwin Simon Genge?
Yes, I am Edwin Simon Genge.
You are currently Director of Legal Services for the Tanzania Commission for Universities.
Yes, precise.
And you hold this position since October 2021.
Yes, exactly.
Now, for part of the time period that we're most specifically interested in here, you were a Director of Legal Services in the Ministry of Minerals from
Yes.
January 2018 to October 2021.
Yes.
Is that right? And you've given us one written statement that was dated the 20th of December 2021.
Yes.
And as you know, you're heard as a witness, and as a witness, you're under an obligation to tell us the truth. Can you please affirm this by reading into the record the witness declaration that should be on the table right there? Yes.
Yes, I, Edwin Simon Genge, solemnly declare upon my honor and the cautious that I shall speak the truth and the whole truth and nothing but the truth.
Thank you. So now we will proceed in the following manner. You might first be asked some introductory questions by Tanzania's counsel, and then we go over to the claimant's counsel.
Okay, thank you.
We have
Mr.
none.
Mende, oh,
We have none, Madam President. We have no any redirect.
thank you.
Thank you, Madam President.
Mr. Dennison, you're the one.
I'll be conducting the cross-examination, yes. Good morning, Mr. Genge. How are you today?
That's good morning, counsel.
My name's Mr. Dennison, and I'll be asking you a few questions today. So, you're a lawyer, Mr. Genge, right?
Yes,
And you graduated from the University of Dar es Salaam with your bachelor's degree in 2007?
yes,
And then you took a master's in corporate and commercial law in 2014, right?
yes,
So, can I take it that you're familiar with company law?
yes,
And in Tanzania, company law would be governed by the Companies Act 2000.
I'm going to ask you to slow down just a
Sure.
little bit. Start that
Apologies,
question again.
yes. In Tanzania, company law would be governed by the Companies Act 2002, as amended, right?
yes,
Now, Madam President, just discussed with you how your role between January 2018 and October 2021, if I'm correct, was the Director of Legal Services at the Ministry of Minerals, right?
yes,
Sounds like an important role, so I assume you would have had oversight over important legal correspondence, for example, to and from the Minister. Is that right?
Pardon, sorry?
In your role as Director of Legal Services, you would have had oversight over important legal correspondence to and from the Minister. Is that right?
No, not all, it depends.
Not all.
Not all correspondences.
Mr. Genge, you say in your witness statement at paragraph 5 that you were entirely responsible for discharging an overall advisory legal function to the Permanent Secretary and the Minister on all legal matters relating to the mining sector in Tanzania. That's right, isn't it?
Yes,
Did you draft any legal correspondence to and from the Ministry?
yes, pardon?
Did you draft any legal correspondence issued to and from the Ministry of Minerals? Did you write any legal
No,
correspondence?
it depends. It depends because my role was actually giving legal advice when requested to do so.
Who were the ministers that you worked for, Mr. Genge, during your time? Who were the ministers for minerals that you worked for during your time at the ministry?
Which minister are you asking?
I'm asking you, who were they? Could you
Yes.
give me their names?
Yes.
Could you tell the tribunal?
I don't have got your question. Sorry, pardon.
My question is, could you tell the tribunal the names of the Minister for Minerals whilst you were working in your role at the Ministry for Minerals?
Okay. During my tenure at the Ministry of Mineral, I worked with the two ministers. The first one was the Honorable Kairuki, and the second one was the Honorable Doto Biteko.
Say the second one, please. Repeat it.
The second one was Honorable Doto Biteko.
Mr. Doto Biteko, is that right?
Yes.
Yeah. So those were the ministers that you had, that you would be advising on all legal matters relating to the mining sector in Tanzania? Yeah.
Yes,
Okay.
wherever they requested for the advice.
Okay. And your role in these proceedings is to provide witness evidence on issues of fact, right?
Yes.
You sure about that? Just issues of fact?
Yes.
Okay. Now, Mr. Genge, in your witness statement at paragraph 137, it might help if we go and look at it. Have you got it in front of you? I think it's in the folder on the left. The other folder, Mr. Genge. And it's on the screen if that's easier. Maybe that's easier. We look at paragraph 137, please. Can you see it?
Yes, I'm there.
Okay. So in that paragraph, you assert that the claimant did not comply with various Tanzanian laws, don't you? You don't remember saying that?
Yes, I'm seeing the paragraph.
Do you remember making that statement in your witness statement, Mr. Genge?
Yes, precisely, I remember.
Yeah. And you stand by that, do you?
Yes.
Okay. Okay, well, let's talk about some of those allegations you make in that paragraph. So let's go back, if we can, to paragraph 108 of your witness statement, please. It's back on page 28. You see it?
Yes.
So you say there that Bafex Tanzania Limited, which held the SMP retention licenses, had a good relationship with the government. Right?
Yes, I can see.
Okay, so I just want to understand your allegations in paragraph 137 that we were just looking at. Do I understand correctly that you're saying that BTL, Bafex, did obey the law, but it's the claimant that you're taking issue with? Is that right?
Yes, pardon, sorry?
Let's go back to paragraph 137.
Yes.
You can see on the screen, 137, it's just coming up, yeah?
Yes,
Yes,
I can see it.
Yeah, you say the claimant did not comply with various host state laws, right?
Yes.
But we just saw that you said that Bafex had a good relationship with the government, and I just want to clarify, to be honest, Mr. Genge, whether you're taking an issue with Bafex or whether you're taking an issue with the claimant.
Yes, I can see the paragraph. What is your question?
My question, Mr. Genge, is do you take an issue with Bafex obeying the law, or do you just take an issue with Helio obeying the law?
Yeah, it's like as I was stated in paragraph 137, it is clear.
So Bafex obeyed the law, did it?
Didn't obey the law because the letters are there. Didn't obey the law because they do not comply with some of the requirements as I was stated.
Okay.
At paragraph 137.
Can I just, I'm not sure this is completely clear. When in paragraph 137 you say the claimant did not comply with various host states' laws, the question is the claimant in this arbitration is Helio Winshear, and are you meaning Helio here did not comply with the law? Are you meaning Bafex Tanzania did not comply with the law?
I'm meaning the one who was granted with the license.
The one who was granted the licenses, yes.
I mean the holder of the license.
Yeah. Okay, that's clear.
Okay, so just to clarify then, the holder of the license was Bafex Tanzania Limited, right?
Yes.
Okay, I just wanted to clarify, it wasn't a trick question, Mr. Genge.
Okay, thank you.
Okay. Now, the first allegation that I'd like to talk about is quarterly reports. Now, you made that allegation, we can see it on screen in paragraph 137 of your witness statement, that the claimant failed to file quarterly reports with the ministry. You see that?
Yes, I am following.
No? Okay. Did you make any investigations into the ministry's records before you came to that conclusion?
I wasn't entitled to make investigation, but these facts are known.
How do you know those facts if you didn't make any investigations into whether the claimant actually filed quarterly reports? Did you just make it up?
So not every facts to be known should be investigated, because there were legal requirements.
Yes, I know there are legal requirements, and you're saying that my client failed to comply with them, Mr. Genge. So I'm asking, what made you come to that
That's
conclusion?
what I'm saying, that if any legal requirement is not followed, does it need any investigation to know that a legal requirement is not followed?
Okay, so just to be clear, you didn't go down to the ministry and check whether any quarterly reports were filed. Is that right?
Yes?
Okay. Now, you may not be aware then, Mr. Genge, but with its reply memorial in these proceedings, the claimant submitted a total of 514 quarterly reports that BTL, BAFEX, had submitted to the ministry over the years. Are you aware of that?
No, I'm not following that question.
Okay. So in these proceedings,
Yes.
the order of the proceedings was the claimant submitted its first submission, its memorial.
Yes.
Then the respondent submitted a counter memorial, and with that, you submitted a witness statement, didn't you?
Yes.
Yeah. Now later, the claimant submitted a reply memorial, okay?
Yes.
And with that reply memorial, after you made the allegation that the claimants had failed to file quarterly reports, the claimant filed 514, or filed exhibits showing that they filed 514 quarterly
Yes.
reports, okay? You following me?
Yes, I'm following.
Were you aware of that before today?
Aware about that?
Are you aware that the claimant had filed all those reports before I just said it to you today? Or is it news to you?
I can't speak on that because I was not responsible to file what was supposed to be filed here. So I cannot talk about that because maybe the respondent could be the one who can talk about that. But I'm here.
Mr. Genge, I'm not asking the respondent, I'm asking you.
Yes.
Before you came to this building today,
Yes.
were you aware that the claimant had filed 514 quarterly reports
Yes.
in this proceedings? You were? Okay.
Yes.
So do you still maintain your allegation on screen in paragraph 137 that BTL failed to comply quarterly reports with the ministry?
Yes. I'm maintaining the content of paragraph 137. Why should I not maintain it?
Well, let's discuss. Sadly, we're not going to have time, as much as I'm sure everyone would love to go through the 514 quarterly reports. I'm just going to show you one of them, okay, Mr. Genge? If you can open that bundle on the left in front of you, or if you like, we can just look at it on screen. It's tab 36 of the bundle if you want to look. Otherwise,
maybe I would prefer to make follow-up on the screen.
on the screen?
Other
Okay,
than
that's
the
fine. We'll show you the things
because
on the screen. And just if at any point you want to look up or down the document, just tell me, okay? Now, on the screen we see exhibit C307,
Yes, I can see it.
and we see that BTL has submitted quarterly reports for the fourth quarter of 2013, right? Can you see it says that?
Yes, I'm following.
Yep. You can see that it's stamped by the ministry.
Yeah, I can see the stamp, but I can't establish whether it is one of the ministry. I can see the stamp.
Well, okay. If we can zoom in on that stamp, perhaps. What does it say? It says Idara ya Madini. Well, I might need your help translating, but my understanding is that Madini means Ministry of Minerals.
Yes.
Yeah, okay. So, do you agree with me that this is stamped as received by the Ministry of Minerals?
I see the stamp, but I can't ascertain it because I was not the author of that. But the stamp is there, I can see it.
Okay, so let me get this straight. You're saying that in paragraph 137 of your witness statement,
Yes.
you're accusing the claimant in these proceedings of
Yes.
failing to file quarterly reports, okay?
Yes.
Yeah? We're now showing you a quarterly report with a Medini stamp on it,
Yes.
and you're still saying that they failed to file quarterly reports.
So I'm still maintaining the
Yeah.
content of paragraph 137.
And if I told you that there were some 70% of these 514 quarterly reports that were submitted, that you now thankfully accept were submitted, at least in these arbitration proceedings, 70% of those bear a stamp of Medini just like that one, okay? If I told you that, would you still maintain your allegation in paragraph 1?
Yes, yes, yes.
Okay, right. Mr. Genge, is it possible that you thought the claimant had not submitted quarterly reports because of poor record keeping at the Ministry of Minerals?
Yes?
It's possible, or do you not understand my question? I just want to get that clear.
Pardon, I have not followed your question.
Okay, that's fine. I'll repeat it. So you make this allegation that the claimant hadn't submitted quarterly reports, right? Is it possible that you made that allegation because the ministry actually just has poor records? It's not very good at keeping records of documents. Is that possible?
It is possible because there are requirements of submitting the reports. Maybe the reports were submitted not following the proper channel.
No, I'm asking you, Mr. Genge, whether the Ministry of Minerals might have poor record keeping. Is that possible? You were there. Yeah?
Yeah, if the ministry does not receive the report when required,
I'm not asking
in accordance
whether it
with the
received
procedures
I've
laid
moved
down.
on. Mr.
Yes?
Genge, I've moved on.
Yes?
Okay? I'm now asking you, does the Ministry of Minerals... I'm asking you whether it's possible that the Ministry of Minerals has poor record keeping. Is that possible?
It has record keeping, yes.
Is that record keeping good or bad? Can you answer my question, please?
Yes, I'm saying that the Ministry of Mineral has a record keeping.
But is that record keeping good or bad? Do those records usually... could you go down and find one? If I asked you to go and find a document at the ministry, would it be easy or would it be very difficult because the record keeping is poor?
No, it is easier. If a certain document is needed, then it can be traced from the record system of the ministry, and you can trace it if it is there.
Let's look at paragraph 42 of your witness statement, please, Mr. Genge. It's on screen. We'll put it on the screen for you. Thank you. I'm interested in the second sentence of that paragraph, which we'll highlight for you. The paragraph's talking about a parliamentary committee that was commissioned in 2007, and it said it put some losses in capital expenditure allowance down to weak documentation of records by the Ministry of Energy and Minerals. You see that?
Yes, I'm following.
So is it possible that the weak documentation continued?
No, that is a general statement.
It is a general statement.
Yes.
I'm asking you whether it's true.
Yes, but that is a general statement. That does not mean that all records cannot be traced.
Does it mean that some records cannot be traced?
Every system may have its weakness, but this is a general statement that maybe weak documentation records of the Ministry of Mineral then can conclude that it is not possible for the ministry to keep records. There are weaknesses on that, but records still can be kept.
Okay. I showed you one quarterly report earlier, Mr. Genge, and if you bear with me, I'd actually just like to show you one other. If we can put on screen Exhibit C452. And we go to page 373, please. You see it?
I'm seeing it, but I don't have seen the document in its entirety. Let me see it.
You want to see it in its
Yes.
entirety? Okay, well, perhaps we can scroll through slowly. Okay, Mr. Genge, in the top right corner of the document there, you see on the screen, it says page 2 of 13, okay? Yeah? So we're going to scroll slowly through those 13 pages. Is that okay?
Yes.
Okay, do you want to just scroll through for him quickly, slowly, Eden? Thank you. I think that's the final page, if I'm not mistaken. Okay, so you've seen it now, Mr. Genge. You've seen what it contains. I don't intend to read it line by line, but if we can go back to the first page, 373.
Oh,
If you wish to look at it more quietly, it must be in a tab. Oh, it's not in a tab.
No, this is, well,
Okay.
thanks. After one of Mr. Genge's answers earlier, we've decided
No,
to...
that's fine.
If that's okay, Madam
But
President.
if you wish to look at something more specifically, we can of course show it to you.
Yes, and I'm sure Mr. Genge, if the Respondents' Council wants to ask you more questions about this, they can take you to it on redirect if there are detailed issues in this document. But I just want to focus on that first page, which is page 373. Okay? So you can see that this is a quarterly report for RL 12 2014, right?
Yes, I can see. Though it is very difficult to ascertain whether it was authored by whom.
Okay, if we can zoom in, just below the title it says Chris Mackenzie, Director. Can you see that? Can you see that?
Yes, I can see.
So this is a quarterly report for retention license number 12 2014, authored by Chris Mackenzie, isn't it? Yes?
Yes, you're saying it.
I'm saying it, but it is one, isn't it?
I can't say that it is easy to, so because you are saying it and I'm seeing it here now.
Can we go up, please, Eden, and have a look? That's a stamp by Medini, isn't it, Mr. Genge?
I am saying I can't substantiate on the stamp because I'm not the one who authored the stamp.
Okay. I'd like to move on then, Mr. Genge, and talk about another allegation that you make in your paragraph 137 of your witness statement that we were looking at earlier. Okay? And that's your allegation that the claimant failed to register its change of name from Helio Resource Corp to Winshear Gold Corp. You remember that allegation?
Yes.
Yeah?
Yes.
And you say at paragraph 113 of your witness statement, I don't think we need to necessarily go there, but you say there that Winshear Gold Corp remains an unknown entity to the BTL shareholding structure. Remember saying that?
Yes.
Yeah. And then you say at paragraph 115, Winshear Gold Corp has no legal capacity to be recognized by the laws of Tanzania as both a shareholder of BTL and an investor in Tanzania.
I think it would be fair if you
that's
just
fine, yeah, I'm happy
quote
to.
this to the witness that he gets a chance to look at it.
Of course, yeah. Can we turn to that page, Eden?
It was 150, 15.
It's page 29. And Mr. Gege, you do have a hard copy of the statement as well if it's easier. Okay?
100? 100?
Just this page, paragraph 113.
Okay.
Sorry. And 115. Those are the paragraphs I just read from, if I'm not mistaken. Perhaps I've got the paragraphs numbers wrong. It may be, paragraph 114 and 15, I think. But you can see it on screen, right? This is the section I'm talking about. So, Mr. Genge, if I understand correctly, your issue is with Winshear Gold Corp, but not Helio Resource Corp. Is that correct?
Yes.
So when you say Winshear Gold Corp has no legal capacity to be recognized as a shareholder in BTL and as an investor, can I take it that your position is that Helio Resource Corp is recognized as a shareholder instead?
No.
I can't take you to that?
I have stated in my witness statement clearly
Yeah.
that under our laws, there were some procedures that you should comply when you change your name.
Yeah.
You can change your name everywhere in the world, but you must comply with some procedures after you have changed your name.
Exactly.
So what I stated is that those procedures under Section 436 of the BLELA Act and the Section 123 of the Mining Act was not exhausted.
I understand that's your allegation. I'm just trying to understand a bit more about where it's come from, because to be honest, it completely baffles me. So, and I'm focusing on now on paragraph 115. You say Winshear Gold Corp has no legal capacity, okay? Did Helio Gold Corp have legal capacity before it changed its name?
Yes, your question?
You say there on the screen, paragraph 115.
Yes.
Winshear Gold Corp has no legal capacity. Those words, yeah?
Yes.
Did Helio Resource Corp have legal capacity before it changed its name?
I have not stated that in my statement, but we recognize the company which was granted with the mineral right.
Yeah, and you recognized Helio Resource Corp as well, didn't you? It's just the change of name that you're taking issue with.
Yes.
Right? Okay. Can we look at Exhibit C2, which is... in fact, we're not looking at your tab, so we can just look at C2 on screen, please. It's tab 17 of the bundle, if that helps. And if we go to page 4, it's the final page. Perhaps we, just zoom out so we can see the whole page there. Thank you. This is a certificate of change of company name, isn't it, Mr. Genge? It's not a trick question. You're a lawyer, Mr. Genge. Does that look like a certificate of change of company name to you?
Madam President, would the council zoom the exhibit on the screen so that I can see properly? I'm having poor vision.
Yeah, which bit would you like to see? And you do have the hard copies in front of you, Mr. Genge. You can turn to those at any time, okay?
Yes. Yes, I've seen it.
Okay, and you'll see that it certified Helio Resource Corp changed its name to Winshear Gold Corp on the 6th of January 2020, right?
Yes, I can see it, but the requirement which I have stated in my statement.
I know. My question was just whether that's what it says for now, okay? We'll get to the requirement, okay? Trust me, we'll get to the requirement.
Okay.
But that's what it says. It says that Helio Resource Corp changed its name to Winshear Gold Corp, right?
Yes, but I can see it. But this change was there, but if it was not registered to the registrar of company in Tanzania, could not suffice.
Okay, but you'll at least agree with me that Helio Resource Corp and Winshear Gold Corp are the same legal entity, right?
Without registering to the registrar of companies in our country. I can't recognize.
Mr. Genge, you told me earlier that you understand company law.
Yes.
If a company changes its name, it's still the same company, isn't it?
It's according to the requirement of the company law in our country, you must
Yeah.
register it.
I'm not asking you about Tanzanian law. I'm asking you about whether, in fact, this is a company, as you can see on screen.
I think it's a little difficult to ask this question. This is not a Tanzanian
Yes.
company, and Mr. Genge is only qualified under Tanzanian law. So, but we can read it.
That's fine.
So
I mean-
I think maybe you move on to the question under Tanzanian law, and then he can answer.
Okay. Well, maybe I can cut to the chase. Do I understand correctly that you agree that this is the same legal entity? It's just the change of name that you're taking issue with?
He cannot state that under Canadian law. He does not know. You can ask whether, in principle, when a company changes its name, it remains the same company. Would you agree with that or not?
Madam President, you know, change of a name of a company is a legal aspect. Elsewhere in the
Yes.
world is also.
Yes.
According to our law, specifically the company's law, if you change your name, you must register that change to the registrar of the company. So my point here my point in my statement is that that was not done in accordance with our law.
I think the point is clear.
With respect, it's not entirely clear to me, and perhaps I'm misunderstanding, but what I'd like to understand, Mr. Genge, is your allegation that just that this entity failed to register its change of name, or are you alleging as well that it is not the same entity? That is what I want to understand. If it's just the first one, we can talk about that, but if it's the second one, I just want to understand it, okay?
You have to speak a little
Sorry.
slower.
Can I answer that?
Sure.
So that's why I'm saying that change of a company, change of the name of a company is a legal process. According to our Companies Act, you mentioned it well. If you have not registered that change, then it is very difficult to establish whether that name is proper.
Okay, but when Madam President asked you earlier that, if I can get the quote, she said, you can ask whether in principle a company changes its name, it remains the same company. And would you agree with that or not? It's still not entirely clear to me the answer to that.
I did not agree. That's
Okay.
what I understood.
Okay, if that's the
because
answer, that's fine.
He considers that
Yes.
you must register, otherwise the name change is not effective or not valid, yeah.
Okay, that's fine. Let me move on. Let's talk about this registration requirement itself then. You argue in paragraph 111 of your witness statement. We can turn to it. It's on page 28. You argue that in Tanzania it's a legal requirement under section 4363 of the Business Laws Miscellaneous Amendments Act, read together with the Companies Act, that restricts a foreign company that changes its name in the country of origin to submit to the registrar a certified copy of the change of name to that effect. You see?
Yes.
Yeah? Okay. And now if we look at tab 18 of your bundle, it's exhibit RL027, page 10. If we just look at that provision 28, this is that section that you're referring to of the Business Laws Act, right? You referred to it in your witness statement, Mr. Genge, so I'm assuming this is what you're referring to. It's not really a trick question.
Yes, section 28 is what we are referring to. Yes, I'm
Yeah, okay.
following.
Okay, good. So let's have a quick look at what it says. It says the Principal Act is amended in section 436 by applying the following subsections. The Principal Act in question is the Companies Act 2002, right?
Yes. What is your question?
That the Principal Act that is referring to is the Companies Act 2002.
No, the Principal Act here, can you scroll down? Again, upward.
I think you would have to.
The Principal Act here is not the Company Act. It's the business laws. It's the business, the BLELA Act is which was amended by that miscellaneous amendment.
Mr. Genge, can we turn to page 7 of this document? And we scroll down towards the bottom of the page. It says Part 3, Amendment of the Companies Act. And if we look at section 17,
Yes.
it says, this part shall be read as one with the Companies Act,
Yes.
hereinafter referred to as the Principal Act.
Yes.
And if we look back at the table of contents, the first page,
Yeah, you are going fast. I am not following.
you said yes, but okay, I'll slow down. Can we scroll down a bit?
Yes, that part 2.
Yeah, that's part 2.
Yes.
And then part 3, Amendment of the Companies Act.
Yes.
Right?
Part 3.
Yeah. And if we scroll down, there it says 28, Amendment of Section 436.
Yes. Yes.
So that paragraph, that section 28 that we were referring to, the Principal Act is the Companies Act 2002, right?
Yes, it is.
Mr. Genge, you didn't submit the Companies Act itself with your witness statement, and unfortunately the respondent hasn't either, so we can't look at it. But given that you're a lawyer familiar with companies law, it seems, perhaps you can help me out. You'll know that the part of the Companies Act that section 28 referred to, perhaps if we go back to page 10.
I have not followed your question.
I know, I'm going to reformulate the question.
Oh, you haven't. Okay.
So we just established that this section 28 is amending the Companies Act, okay? Right?
Yes.
Yeah.
In section 436.
Mm-hmm. And section 436 and the surrounding sections of the Companies Act, those sections concern foreign companies, right?
Yes.
And foreign companies is a defined term of that section of that Companies Act, right?
Yes.
Yeah. And those foreign companies are required, if they have a place of business in Tanzania, to register with the Tanzanian Companies Register, right? Under that part of the Companies Act?
I'm not following because I don't have that part you are reading. Maybe if you.
So you don't know. I'm just asking you off the top of your head,
Okay,
because
okay.
you did a master's in corporate law. So
Okay.
if you don't know off the top of your head, that's fine. You can just tell me. You don't know?
Mm-hmm. Go on.
I'm relying on your knowledge as a company lawyer in Tanzania here, okay? Do you know that section of the Companies Act relates to foreign companies?
Yes, the definition section.
Definition, yeah. And that definition defines those foreign companies as companies that have a place of business in Tanzania. Do you remember that?
So I remember that, but I don't know whether the definition is very narrow like that, the way you are making it. Why can't
Okay.
you read it entirely?
That's fine. If you don't know, then that's fine, Mr. Genge, and sadly we can't check because you didn't submit the Companies Act.
Okay,
so
thank you.
I'll move on. Although, out of interest, do you remember what the consequence was if a foreign company failed to submit to the company's registrar its change of name? Do you remember what? It was an administrative fine for failing to make a company filing, right?
Yes, the consequences?
The question is, if a company, the allegation you make in your statement that the
Yes.
company failed to make its company name, that's what I'm talking about, okay?
Yes.
If a company fails to do that, as you allege the claimant did, the consequence under the Companies Act was an administrative fine for failing to make a company filing, isn't it?
That's one of the consequences. But the other, the company, can't be recognized.
Has Tanzania ever issued Helio or Winshear an administrative fine for failing to comply with that provision?
I am not certain.
You're not certain.
Yes.
So there's this other allegation you make about failing to inform the Mining Commission as well. Remember that?
Yes.
Yeah. And you say that's under Section 123 of the Mining Act 2010. It's a let's look at your witness statement. It's at paragraph 114. So you say, I'm aware that the provisions of Section 123 of the Mining Act requires that any changes/variations to the company should be registered to the Mining Commission. You see
Yes.
that? Yeah? There's no Section 123 of the Mining Act 2010, Mr. Genge, is there?
Yes, your question, please.
My question is that there is no Section 123 of the Mining Act 2010, is there?
But I don't know which version you're reading because which version of the Mining Act? Maybe you may not be reading the revised one.
I know full about the revised one. I'm referring to this company's the Mining Act 2010. Yeah. Before it was amended, there was no Section 123, was there?
It was there.
Let's
There
look
was
at
other section which was imposing that requirement
Yeah.
to the companies. But after the amendment, actually, the act was revised. So the provisions of the act were changed accordingly.
Yeah. Okay. Well, let's explore that. Let's look at tab 20 of your bundle. It's Section 120. Sorry, it's C218. So this is the Mining Act before it was amended, right? You can take my word for it. It is. If we go to page 78, please. You see, if we zoom in on section 106,
Yes.
that's the section that became section 123 after the July 2017 amendments, isn't it?
I can't ascertain it, but the content of it sounds like the section 123.
Okay. So this is the section you were referring to in your witness statement, isn't it?
Yes.
Yeah. Okay. Now, this section, the section on screen, we don't have, just to be clear for everyone, we don't have the version with section 123 in it because the way the legislation worked is that it just amended the numbers without actually reissuing the document itself. But I think we've established with Mr. Genge that this is the section he was referring to. So this section 106, which became section 123, it doesn't say anywhere that the shareholders of a license holder must inform the Mining Commission if they change their name.
No,
It doesn't, does it?
I have to say that this section was not amended.
No, it wasn't. And I'm looking, if you look at it on screen.
Yeah, in my statement I have said, I've cited section 123.
Yeah, and you just agreed with me that this became section 123.
Yes.
Yeah. And you agreed with
I'm
me
not
that
sure
this
whether this one became section 123.
Okay. Can
But
you
in my statement I have cited Section 123 was not followed.
Well, what I'm trying to help everyone in the room understand is that Section 123 is this provision.
I
don't
can't
know.
ascertain
You don't know,
because
okay.
I can't ascertain
You don't know.
because I did not revise the Mining Act.
Can we look at Exhibit RL03? I don't think it's in the, it might not be in the bundle because we weren't planning to take you to it. But perhaps we could get it up. We're looking at this is the respondent's version of the Mining Act that it submitted. And if I understand correctly, the respondent submitted it as the revised version. There's no Section 123 in this either, is there? There's no Section 123 there, is there?
It is there because in our country also a legislation is revised. Then the previous one cannot be relied on.
So, Mr. Genge, can I get this straight? You refer to Section 123 of the Mining Act in paragraph 114 of your witness statement,
Yes, of
Yeah.
the revised edition.
of the revised edition,
Yes.
but you can't tell me, we just looked at two versions of the Mining Act and you can't tell me which provision you're referring to.
I can't because
You can't.
this one cannot be relied on because it has been already revised.
So this tribunal has no way of checking that what you said about Section 123 in your Mining Act is correct, do they?
I said it in the revised edition.
But you're telling me that we can't find the revised edition and you can't find Section 123?
Well, I doubt
I-
that he knows the entire record, right? So it's difficult for him to know whether we can check
This-
or not.
Okay. Can we go back to your witness statement, please, Mr. Genge? In paragraph 114, the first sentence says, I'm aware that the provisions of Section 123 of the Mining Act, and then you put a footnote, footnote 61. Footnote 61 is to RL003, the Mining Act 2010. That's the exhibit we were just looking at, isn't it?
Yes, that is the revised edition.
Can we go back to that exhibit, please, Ms. Jardine? Where in this, the one that you just referred to in your witness statement, is Section 123?
I don't know whether this one is the revised edition. You know, I was not responsible to bring documents here, so
So you didn't
I
look at
can't
any of the-
ascertain whether this version we are referring to is the
Yeah.
revised edition.
Well, I'm just referring you to an exhibit that you cited in your witness statement, Mr. Genge. Did you look at any of the documents you cited in your witness statement before you submitted it?
I could not get that.
You didn't.
I could not. I didn't get that opportunity because I got up not well today.
Okay, maybe we'll come back to that later. I'd like to talk to you now about the parliamentary process that led to the enactment of the amending legislation. And by the amending legislation, I mean the three acts that were passed in 2017. You know the ones I'm talking about?
Yes.
Yeah. Now, we heard in the respondents' opening submissions on Monday about how usually in Tanzania bills are submitted to Parliament at least 21 days before the first reading. I know you weren't there, but that's right, isn't it?
Yes.
Yeah. But in the case of the 2017 legislation, those acts were passed under an emergency procedure, weren't they?
Yes.
And that meant that the government could dispense with the normal parliamentary process because it was an emergency, right?
Yes.
But that meant that a document had to be submitted to a parliamentary steering committee, an emergency document, explaining the emergency in question, right?
Yes, but which document are you referring to?
I'm referring to the parliamentary procedure under which, if there is an emergency bill, there had to be an emergency document submitted to a parliamentary steering committee explaining the emergency that was going on, right?
Yes, go on.
There was no certificate of emergency, no emergency document issued for the July 2017 legislation, was there?
Yes, as far as I'm concerned, the procedure was followed.
Yeah, okay. I know that's what you say in your statement, but I'm asking you that there was no emergency document issued for that legislation, was there?
I can't substantiate that because
You
I
don't
was
know?
not part of the procedure.
You don't know?
Yes, I don't know.
Did you ask to see the emergency document with your own eyes
No.
when you were preparing your witness statement?
No.
No. And you're aware that the respondent hasn't, well, probably you aren't actually, but I can tell you that the respondent has not produced the emergency document in these proceedings, so we haven't seen a copy of it. But did they tell you that there was a certificate of urgency, the emergency document?
Yes.
They told you, okay. But you don't know for certain yourself whether one was ever issued?
Yes, I don't know. I couldn't ascertain that because I was not part of the process of amending the law.
Yeah.
That's the task of the parliament.
Okay. So let's go to paragraph 136 of your witness statement, please. See it? You've read it?
136.
Yes.
Yes, I've seen it.
You say that the repeal of provisions of sections 37 and 38 of the Mining Act 2010 relating to retention licenses followed the procedures for enacting laws in the United Republic of Tanzania.
Yes,
Yeah.
precisely. I said that.
You said that, but you just told me you don't know whether a certificate of urgency was ever issued.
But maybe if you can allow me to explain the procedure.
I don't want to explain the procedure. We
So-
went over it in
okay,
detail on Monday, trust me.
as far as I'm concerned, Madam President, the procedure of amending the Mining Act, which was conducted in 2017, was followed.
Maybe just on my time, what is the procedure?
Now, in our country, if the state or there is a process of amending a law, there are two procedures. The law can be amended or enacted by using an ordinary means of using bills, and there is another procedure which is under certificate of urgency. And in this case, the amendment of the Mining Act, which was done in the year 2017, used the route of under certificate of urgency. And all the requirements under this procedure were complied. That's what I stated in my statement, and I reiterate on that, Madam President.
Thank you. That's clear.
So, Mr. Genge, at that time, when the 2017 legislation was passed, you were working at the Tanzania Education Authority. Have I got that right?
Yes, I joined the Ministry of Mineral in January 2018.
Yeah. And you just said to me earlier that you haven't seen the certificate of urgency with your own eyes. So how can you know that the procedure was followed, as you state in your witness statement, if you've never even seen the document?
Yes, being the director of the legal director in the Ministry of Mineral by the time, why not allow it even to read and to know what perceived in the ministry? It wasn't necessary for me to know that I couldn't be the director by the time the amendment was done. It wasn't necessary. I could know even later after the amendment had been
I
made.
understand that. I understand that, Mr. Genge, but you're telling us that you've never seen this emergency document, aren't you?
I'm saying that I didn't see it because not maybe it wasn't there, or it was there because I think in a discharge of my duty in daily duties, I may have not seen it because the certificate of urgency, if issued, it is issued by the upper authorities.
Okay. So just, yeah, okay, that's fine.
So it
Move
is
on.
not a document to be under my consumption.
That's fine, Mr. Genge, I understand your position. So under this emergency procedure, as I think we've already established, the emergency document would set out the reasons why the bill in question is urgent, wouldn't it?
So here, the reason for the amendment was set only within the bill.
I'm not talking about the reason for the amendment. I'm talking about
I
why.
I have said,
No,
Madam
Mr. Genge,
President,
can I
I have
finish my
said,
question, please?
Madam President, that I haven't seen the emergency certificate. I didn't see it. So I think it's not proper for me to talk for a document which
I'm
I
not
would
talking
perceive.
about the document.
You have to be careful to wait a moment before you start speaking, because otherwise we have overlaps and the transcript doesn't reflect what is being said.
Yes. Sorry, Mr. Genge. Sorry for interrupting you. And perhaps if we both try to stop interrupting each other, we'll get to the end faster, okay?
okay, no problem.
So what I'm asking you is, normally, I'm not talking about this specific one anymore. I'm talking about the parliamentary rules in Tanzania that you say you know about. Normally, this emergency document would set out the reasons why a given bill, is urgent, wouldn't it?
No, it depends. It depends with the process, with the process of amending the law.
Should we look at tab 11 of your bundle, please, Mr. Genge? It's Exhibit C433. And if we scroll down to section 85, this is talking about the emergency procedure. And it says, the bill shall first be submitted to the steering committee accompanied by an emergency document, so that the committee may determine whether the relevant bill is to be submitted as a matter of urgency or not.
Can you just specify what the document is?
This is Exhibit C433, which is the parliamentary standing orders of the Tanzanian Parliament.
Thank you.
Yes, I'm seeing it.
Yeah. Do you agree that that's the provision, that the relevant legal provision talking about the emergency procedure in Tanzanian parliamentary rules?
Yes.
And you agree with me that this provision, the purpose of the emergency document under this provision is that the steering committee can determine whether the relevant bill is to be submitted as a matter of urgency or not. Right?
Yes, there is that discretion.
Yeah, but that's the purpose of this emergency document, right?
Yes.
Yeah. In 2017 in Tanzania, in particular in July 2017, there was no natural disaster and no war or no other kind of emergency, was there?
No, that is not the way we define emergency in our country.
But I'm just asking you whether there was one. There wasn't one, was there? And there's no war, no disaster, no threat to national security. There was no emergency at all, was there?
But that's not the way I can perceive emergency.
Okay, let's look at how emergency was perceived by Mr. Magufuli, the president. If we turn to tab 12 of the bundle, which is exhibit C435. If we scroll down, so we can see this is a press article, we scroll down to the third paragraph, which is just under that red box, you see? And if you zoom in a little bit, perhaps, thank you. So you see it says, speaking at a public rally on Tuesday, Magufuli said he had decided to rush through bills because the country was in the midst of an economic war. See it says that?
No, I don't know. Which document is this?
This is a press article by a publication called mining.com.
Maybe you scroll up.
Yeah,
so
if we scroll up to the top.
witness can see what it is.
If you zoom in on the link at the very top, Ms. Jardine. Can you see that? It just says mining.com. Yeah? That's what the document is, okay?
Well, Madam President, I don't think whether this suffices to define what is emergency now, because this is just a mere newspaper.
I'm not asking you whether this suffices, Mr. Genge. I'm asking you whether that's
So
what it says.
to me, what is spoken here, it should be established whether it was official for what the president was quoted, but that was not the emergency as is referred in the parliamentary order.
You see after the highlighted bit on screen, Mr. Genge, it says Reuters reported, doesn't it?
I think the point is that this is a news report and is not an official document.
So, Mr. Genge, the real reason for passing the draft bills was that Tanzania was in the midst of an economic war, wasn't it? That was the reason that the emergency procedure was used.
No. The reason was the implementation of the recommendations in the various committees which were formed there before 2007, and also a continuous process of implementing the objectives of the Mineral Policy 2009. That were the reasons for the bill and for the amendment.
So there was an emergency from 2007 all the way to 2017, was there?
Yes.
Okay. Let's move on, Mr. Genge. Let's talk about, in fact, perhaps before I move on, we were going to ask Madam President whether now would be a good time for a break. Happy to carry on if that would be more convenient. Otherwise, we're also open to having a break. I'm asking you, we're very much in your hands.
I think it's a reasonable time to have a break, absolutely. Let's take 15 minutes until 11:45. And during the break, Mr. Genge, I have to ask you not to speak to anyone about the case and the facts and your testimony, and therefore it's better not to speak to anyone. But of course, you can go and get a coffee or a tea.
Okay, so I should remain in the room.
You can remain here, or you can go and get something to drink, but you should not speak.
Okay, got you, Madam President. Thank you.
And you can switch off your microphone while you
Madam President, we're ready on the claimant side, and I think we just heard from Mr. Mandapo that he's ready as well. Is that right?
Yes, we're ready to proceed. We are ready, yes.
I wasn't sure,
Oh, they're coming.
but I'm sure you can handle it. Good. But Mr. Genge is ready as well.
Yes, I'm ready, Madam President.
Good. So we can go ahead. Mr. Dennison.
Thank you, Madam President. I'm going to try and wrap it up now quickly, Mr. Genge. You'll be pleased to hear. So you confirmed to me at the beginning that you were in charge of advising the Minister for Minerals on all legal matters relating to the mining sector in Tanzania, right?
Yes, I was the director.
From January 2018 onwards?
Yes.
And it was in January 2018 that the existing retention licenses were all cancelled and returned to the government, right?
Yes.
Did you join before or after that? Because it was in January 2018. So were you at the Ministry of Minerals already when that happened?
I was already present in the ministry.
Okay. So after the January 2018 regulations cancelled the retention licenses, do you remember that BTL, Bafex Tanzania Limited, wrote to the minister asking whether the government intended to expropriate the SMP Gold project?
I don't remember.
You don't remember that?
Yes.
Let's have a look then. It's tab 37 of the bundle, which is Exhibit C195. Put it on screen for you again. So if we just take a look at what this document is. This is a letter from Bafex Tanzania Limited to Minister Kairuki, right? If we just stay at the top for a second.
Yes, I can see it.
Yeah?
I can see it here.
Minister Kairuki, who you said you advised. And it's dated the 24th of January 2018, isn't it? Yeah?
Yes, I can see the letter.
Okay. I just need you to confirm for the record because the transcriber needs to write down your answer, so I just need to get you to say it. And if we scroll down the letter, it says, so this is Bafex Tanzania writing to the minister. It says, I trust this letter finds you in good health. I'm writing to formally request a meeting with you to discuss the newly released mining laws, specifically the treatment of retention licenses. And then if we go down to the third paragraph, it says, although we have not received any official letter from Medini, our reading of the new laws suggests that our retention licenses are to be expropriated by the Tanzanian government. You see it says that?
Yes, I can see the paragraph.
And it says, we would like to think that is not the intention of the Tanzanian government, but could you please confirm what your position is? Right?
Yes.
And can we scroll down to the bottom? That's signed by Mr. Richard Williams, director, right?
Yes, I'm for it.
Have you seen this document before, Mr. Genge?
No.
You haven't seen it before?
Yes, when during my course in the ministry, I didn't see this.
You didn't see it, okay.
Yes.
Are you aware then that on the 12th of March 2018, Bafex and Helio again wrote to the deputy minister this time, Minister Biteko, who you also advised? Do you remember that?
No.
Let's have a look at that one. It's tab 38, the next one. Exhibit C156. Do you recognize this document?
Yeah, I'm seeing the document here on there.
Do you recognize it? Do you remember seeing it before?
No, I don't have seen it. I happen not to have seen this document
No. Okay.
during my course as director in the ministry.
Okay. And we can see the title of the document saying Proposal for the Development of Bafex Project Area, right? You see it says that?
Yes, I can see. It was written to Deputy Minister. Yeah.
And then down the page, you see there's a numbered list of bullet points. And number 1 is the retention license areas are reissued as prospecting licenses, right? You see it says that?
Yes.
I know you haven't seen it before. I just
Yes,
wanted
I'm
to-
seeing there.
So those 2 letters we've just looked at are essentially, let's just confirm. Sorry, I've missed out something. If we go to the top again, in the first paragraph, just for the record, it says, we're very pleased to have been able to discuss our project at Saza Songwe region with you through Dr. Arnold Maturi during your visit to the tour of Songwe, right?
Yes, I
Yeah,
can see.
and it's addressed to Minister Biteko. Yeah, Deputy Minister Biteko.
Yes.
Yeah? Were you with Deputy Minister Biteko during that visit to the Songwe region?
No,
You weren't, okay.
I wasn't there.
Okay. And if we look on the back page, just for the record, Mr. Genge, because I want to understand what this document is. It's signed there by Richard Williams, CEO and Director, right?
Okay, I can see.
Yeah, you see that? Okay. So these 2 letters, Mr. Genge, they're asking for the ministry's legal position about the retention license, aren't they? The retention licenses.
Yes, if the letters were received, but I don't see whether they were received by the ministry.
Okay. Well, you say you never saw them. Are you aware that Helio had quite a bit of contact with Deputy Minister Biteko over the following months after these letters and that meeting?
Yes, but pardon your question?
Sorry, let me slow down. Are you aware that after this letter, which is dated the 12th of March 2018,
Yes.
Helio, the claimant in this proceeding, it had a lot of contact with Deputy Minister Biteko?
No,
No?
I'm not aware.
Let's look at your witness statement, paragraph 123. And in the middle of the paragraph, you say, Helio continued to engage on site and further acknowledge that Deputy Minister Biteko was very supportive of Helio continuing to develop the project. You see it says that?
Yes.
You remember writing those words?
That was the statement of Mr. Richards in his witness statement. Mr. Richard Williams claimed that in his witness statement.
Mr. Genge, you're saying it can be seen from paragraphs 134 to 140 of Mr. Williams' statement. So you're agreeing with it, aren't you?
Yes, I'm saying that it can be seen, but I don't believe that.
You don't believe it?
Mm.
You don't know or you don't believe it?
I don't believe that in the statement of Mr. Williams.
So you disagree with Mr. Williams? So you say that Helio didn't engage on site?
Yes, it was stated in his witness statement.
Yeah.
That's why I'm saying it can be seen. But I don't believe in the truth of what is stated.
Okay, so you're saying that Mr. Williams lied in his witness statement?
I don't believe in it. It's different from saying that Mr. Williams is lying.
You don't know whether Helio continued to engage on site?
Yes.
You don't know?
I'm not certain.
So you weren't present at any of the meetings between Deputy Minister Biteko and Helio that were referred to in those paragraphs?
No.
Okay. Mr. Genge, you also mentioned in your witness statement how in November 2019, the Commissioner for Minerals wrote directly to Helio indicating that Tanzania was preparing a procedure to reissue licenses. Remember that?
Yes, again,
It's in the next paragraph.
Yes, again, this is what was stated by Mr. Williams in his statement.
Yeah, it says the claimant further acknowledged that, right?
Yes, I read that in his statement.
Yeah. And then at the bottom of the paragraph you say, this means by its own statement, by November 2019, there was no any expropriation of the retention license. area. So you're agreeing with it, aren't you?
That, yes, no, there was no expropriation.
I'm not talking about the expropriation. I'm talking about whether you agree that this letter was sent in November 2019. Do you?
I stated in my statement that there was no expropriation of the retention license.
Let's turn to tab 40 of your
So
bundle,
I was
Mr. Genge.
disputing what was stated by Mr. Richard Williams in his witness statement.
It's Exhibit C 202. You see that? And it's a letter from the Ministry of Minerals to CEO and Director, Helio Resources Corp. You see that?
Yes, can it be zoomed a little bit? Yes. Okay. Yes, I can see.
And it's dated the 20th of November 2019, right?
Yes.
Did you draft this letter?
No.
Do you remember seeing it at the time? Have you ever seen this letter before, Mr. Genge?
Yes, yes.
You have?
Yes, I've seen it before.
Sorry. Mr. Genge, you just told me that at paragraph 124 of your witness statement,
Yes?
it was untrue that this letter was ever sent.
Why? Why absurd? This is a letter which was the commissioner for minerals.
Yeah. So, Mr. Genge, we were just looking at paragraph 124 of your witness statement. We can look at it again.
Yes, yes.
Yeah.
Yes.
And it says, it's talking about this letter dated November 2019, where the Commissioner for Minerals wrote directly to Helio, I'm reading from your statement,
yes.
that indicating that Tanzania was preparing a procedure to issue licenses in the areas formerly covered by retention licenses.
Yes.
That's the letter that we just looked at, isn't it?
Yes. And now the letter is showing the intent of the government on how they could handle the rights of the previous holders of the retention license, which was cancelled in 2019, following the regulation.
How they could provide them with an alternative license, is that what you said? How
Yes.
they could end the rights? Sorry, I didn't quite catch it.
I am saying that the letter, which is signed by the Commissioner for Minerals, was written to the climate in order to show the intention of the government on how they could handle
Yeah.
the areas under the retention license following the cancellation resulted by the amendment of the Mining Act
Yeah.
2019.
Yeah.
And
then in December-
specifically, this one was after the promulgation of the Mineral Rights Regulation 2018.
Yeah, and then in December 2019, the
Yes.
government then issued its invitation to tender, right?
Yes, pardon?
In December 2019,
Yes.
so the next month,
Yes.
on the 19th of December, the Ministry for Minerals issued an invitation to tender, didn't it?
I don't know whether it was the minister or the Mining Commission.
You don't know?
Not the Minister of Mineral, the Mining Commission.
Okay, so did you have no involvement in that?
No.
You had no involvement in that?
Yes.
Okay. Mr. Genge, another of the former retention license holders was Kabanga Nickel Company, right?
Yes, pardon?
So there were lots of retention license holders before they were cancelled, weren't there? 8 in total, actually. Are you aware of that?
What do you mean by your question, sir?
Okay.
I have not followed you properly, maybe. You make it easy so that I get it.
I'm trying to, and I'll slow down. We agree there were retention licenses in Tanzania, don't we?
Yes?
Yeah. And we agree that certain companies held those licenses before they were cancelled.
Yes?
Yeah. And Kabanga Nickel Company Limited was one of those companies, right?
Yes?
And Kabanga Nickel Company Limited was a joint venture between Glencore and Barrick at the time, right?
I can't recall.
You can't recall.
I can't recall that, yes.
Okay. Let's look at paragraph 121 of your witness statement. You give Kabanga Nickel Company Limited as an example of, and I'm using your words, successful engagement with former retention license holders, don't you?
Yes,
Yeah.
precisely.
Yeah. So you give it as an example of a company that the government engaged with successfully to reach a deal, right?
Yes.
Let's look at tab 29 of your bundle. It's exhibit R42. You see it? Yeah? Maybe we need to
If
zoom
you
in a
can,
little bit.
if you can zoom it a little
Yeah,
bit. yes.
exactly, yeah.
Now
Okay.
I'm following, yes.
So this is a statement by the UK company Kabanga Nickel Limited, right? And it signs a binding framework agreement with the government of Tanzania for the development of the Kabanga Nickel project. You see that?
I can see.
Yeah?
Can you see?
This is the deal that you were talking about at paragraph 121 of your witness statement, right?
I'm not certain because
Because
I could not see this. There was a deal, but I was not acquainted to the agreements. So I'm not sure whether this is the proper agreement between Kabanga and the government. But I agree there was the agreement between the Kabanga and the government on the same issue you are referring
Mr.
to.
Genge, can we turn back to paragraph 121 of your witness statement? And if we zoom in on that highlighted section.
Yes,
You
I'm not disputing that.
No, you're not. And what I want to show you is the footnote 62 that you put at the end of that highlighted section. Yeah? And that footnote leads us to exhibit R42. That's the document we were just looking at, isn't it?
Okay.
Yeah? So do you agree with me that the deal you're referring to in paragraph 121, in that highlighted section that we were just looking at, is the deal that document was talking about?
It was the deal. It was the deal between the government and the Kabanga,
Okay.
and that is not
We got that.
disputable. Yeah.
We got that, thank you. Mr. Genge, are you aware that Kabanga Nickel Limited is not the same company as Kabanga Nickel Company Limited?
I cannot ascertain that.
You can't.
Yes.
Let's go back to the exhibit R42 then, please. And if we go down to page 2, in fact page 3, sorry, at the back, the last paragraph of the document, the very last paragraph, yeah. Perhaps we can zoom in on that paragraph saying about Kabanga Nickel Limited. It says, Kabanga Nickel, brackets, formerly LZ Nickel Limited, close brackets, is a privately owned company established in 2019 to acquire and develop the Kabanga Nickel project in Tanzania. You see that?
Yes, I can see.
Yep. And we go back to the previous page. The third paragraph from the bottom, I think we just went past it, yeah, where it starts with on Minister Kabudi. Do you know who Minister Kabudi is?
Yes.
Yeah, he's the guy that introduced the amendments cancelling the retention licenses, isn't he? He says he is, isn't he?
Yes, your question?
My question was, he's the guy that introduced the amendments in the legislation that that repealed the retention license category, isn't he?
I don't know whether I can subsession before this tribunal about the company of Kabanga so much, but what I know is that Kabanga reached a deal with the government after negotiating with the government following its retention license.
We'll talk about
to
that.
be cancelled. Yes.
My question for now, Mr. Genge, is: do you know that Mr. Professor Kabudi was the man who introduced those amendments to the legislation? It's a quick question. Yes or no?
In the parliament.
In Parliament, yeah.
Yes,
Yeah,
yes.
he was, okay. And he says, we welcome our new partners in that paragraph, right? You see? And we go back to page, you see it, right?
Yes?
Yeah. We go back to page 1. If we go to the footnote 1 of that page, the framework agreement has been signed by LZ Nickel Limited, which subsequently changed its name to Kabanga Nickel Limited in the region.
Yes, I can see.
Okay. I have no further questions. Thank you.
Fine. Any questions and redirect?
Yes, we have a few. Mr. Genge, my colleague asked you about introduction of the bills to the parliament. You remember?
Yes, Council.
And he asked you whether there was any emergency for the bill.
Yes, I can recall.
Yes, was there any emergency?
Yeah, according to our law, there was emergency, but the procedure which was adopted was the one which I stated during my cross-examination interview with the council, that in our country, and according to the Parliamentary Standing Committee, Order 18, sub-order 4, is that once a bill is considered an emergency bill, that it should go to the Parliament under certificate of urgency, then it is submitted to the clerk of the National Assembly, and then the clerk of the National Assembly proceeds with the sessions of the Parliament and the other procedures that could fall in the Parliament. That's what I stated.
Was the bill rejected in the parliament?
No, it was passed.
And
The bill was passed in the Parliament.
And my colleague also asked you about the Companies Act in Tanzania, and specifically in relation to status of Winshear, right?
Yes.
It appears that according to your statement, there was no record with the register of companies. So there any consequences?
Yes, if a company changes its name elsewhere, it will be in Tanzania or elsewhere in the world, the requirement under Section 436, subsection 3 of the Companies Act is that you must submit formally the certificate of change of name of the company. Now, failure to do that, then the company will not be recognized its existence in Tanzania. And there are other consequences, of course.
And we understand that according to you, that Erio is the one of companies owning Buffex, right?
Yes.
According to you, what are now in the record in Tanzania?
We recognize the company which was granted with the mineral right.
Sorry?
The company which was granted the mineral right is the one which is recognized in Tanzania.
Okay, Madam President, I don't have any further question.
Thank you. Do my colleagues have questions? Edward, do you have questions for him?
You mentioned in
Your microphone.
I'm sorry. You mentioned in your statement, or written witness statement, that the claimants did not file any annual quarterly reports at the Ministry of Minerals. But the claimant, when he was cross-examining you, pointed to several quarterly reports that had been filed with the Ministry of Mines. Why then did you state that the claimant did not file any annual reports?
Yes, because the procedure there before, when the retention license was granted to Perfect, the law required the order of the retention license to file the reports before the Commissioner for Minerals, and therefore the report which was submitted here was submitted to the Mining Commission, but the law did not require them to file it to the Mining Commission. It was to be filed before the Commissioner for Mineral. That's why I failed to recognize them.
I see. Okay. Okay. Thank you.
Thank you. During your cross-examination, you were asked about the emergency document for the emergency procedure in the Parliament in 2017. And at some point you said there was an emergency since 2007. Is that what do you remember saying that, or did I misunderstand you?
I was asked that question by counsel, the way he defines emergency circumstances.
Exactly, yes.
But I'm saying that those were not the emergency circumstances we could define under the law in our country. But the procedure of amending the Act followed an emergency in accordance with the, our law.
And what was this emergency? Can you just tell us? Even I understand you have not seen the emergency certificate, but you must have some kind of understanding of what the emergency was.
The emergency could be determined by the steering committee.
Yes.
Could be determined by the steering committee, but these amendments were made as a result of recommendations made by various committees in the previous years, from 2002 up to the year 2017. There are other outcries of the general public on what the nation could get from the mining sector. And following that recommendations now, the state could see that it was high time. It was high time for the Mining Act to be amended so that what the nation was expected to get should be achieved from the mining sector. And one of it was that the environment of trying to produce the mineral resources in our country could not benefit the nation in one way, and also in another way it could not benefit the investors. So one of the major efforts that was made by the state was to amend the legal framework in the mining sector so that production of minerals in the mining sector could benefit both the state in one particular and the investors in general. So given those circumstances and the recommendations which were issued by various committees in the previous, and the need also to implement the objectives of the mineral policy of 2009, that was one which was in our country could be regarded as the major circumstances to make the amendment.
So that is the win-win idea that one finds in different places in the record.
Yes.
Yes, I think President Magufuli also used the notion of win-win situation.
Yes, therefore to achieve that win-win situation, yes.
Yeah.
But there was no intention of targeting foreign investors. It was to ensure that the state and the investors, they achieve what they expect in a win-win situation.
And to what understanding this overall purpose, what was the contribution to this purpose of the abolishment of the category of retention licenses?
Madam President, as I have said, the category of the retention license was cancelled as a result of the amendments of the Mining Act of 2017. There was no specific reason which targeted the retention, but the objective of the amendment was to achieve a win-win situation. So the abolition of the retention license, of course, was thought that it was one of the efforts that could ensure that the state is getting its share in a win-win situation, and the investors also, they get their share in a win-win situation.
Yeah, you actually say somewhere in your witness statement, paragraph 134, if I'm not mistaken, that the idea is that these areas become productive.
It was there, but the other reason was that the retention licenses also were not used properly. The orders, of course, also used the retention license as a way which maybe could not be seen as one which could ensure equitable share to the nation, because some of the holders used a number of years without going to the mining operation.
Yeah.
So one of the gear to ensure them that the holders could now start mining. Well, now the state could see that it was a high time now to think of another category of the mineral right which could ensure the state to get the equitable share, and without any kind of abusement to the mineral rights.
Going back to the emergency procedure, is this a procedure that is, from your knowledge, often used in Parliament? Is it very unusual? Does it happen once a year?
Madam President, the certificate to procedure, first of all, is a statutory process.
Yes, I'm not asking about the statute or the procedure. I'm asking about the Parliament's practice or the government's practice of asking the Parliament to process the bill in an emergency procedure. Does that happen often, or is it very exceptional?
It depends with the circumstances. And it is often in some of the bills. For instance, when the bill is maybe actually the bill for in relation to man bills, the procedure is also used. And
in relation to what?
in relation to bills relating to taxes and the other matters, the procedure could be used. The same procedure could be used.
Is it used?
Is used by the parliament.
Is used?
Yes.
Or can be used?
Can be used.
Can be used, yeah. And then in January 2018, you joined the Ministry
Yes, of mineral.
of Minerals, yes. And that is when the cancellation of the existing retention licenses occur.
Yes.
What can you tell us about why this was done? Because one could think that you can abolish a category in the law, but not touch the retention licenses that have already been granted and just wait for them to expire. Now, why was it chosen to cancel them? Would you know that? By that time, you were in the ministry.
I couldn't know that, but because the law was enacted by the parliament, and I wasn't part of the member of the parliament, and the reason for the amendment is best known by the parliament.
Yeah, but I have no member of parliament
Yes.
here, so I am.
But the reason
you.
why the abolition, I have spoken it was the implementation of the mineral policy, objectives of the mineral policy 2009, and including even the other circumstances that there was abuse also of those rights. So the state could think that abolishing them is the best way where equitable share in the mining and the natural resources could be achieved by both parties in a win-win situation. The government in one hand and the investors in another hand.
Yeah.
Because this was not only done on the foreign investors, even the domestic companies also.
Yeah, I understand that.
Yes, were
Absolutely,
affected, yeah.
Good. I don't think I have any further questions. Yes, sure.
In the course of when you joined this ministry, were you able to ascertain why or the reasons for the abolition of these, cancellation of these retention licenses?
Yes, I was able because what geared the amendment was the effort which were made previously by various committees which were trying to see how and which way could be used to ensure that the mineral sector could benefit the nation. So there were various committees formed, and even the mineral policy as it is today, the mineral policy of 2009 as it is today, allows the government to continue implementing the objectives. And one way of implementing the objectives of the mineral policy 2009 is to make amendment in the Mining Act so that you can achieve what is stated in the policy.
But what was the policy? Why was this retention licenses cancelled?
That's what I said, that if we could read the mineral policy,
Sorry?
one of the objectives of the mineral policy was to ensure that extraction of mineral in the mining sector is done in a win-win situation between the government on one end, and the investors, whether domestic or foreign investors. Now, as I said, that you could just see, for instance, the case of the climate. The retention license were issued to them, but there was no effort that could show that the order of the retention license could complete the stage of exploration, because a retention license is granted to an order who must have completed the exploration stages. Now, in some cases, you could just see that some orders were, instead of showing that they have completed exploration stages, they were still asking for extension for exploration activities, instead of requesting for a special mining license, which could enable them to start mining operation. So these and the other factors which were recommended by various committees, from the committee, Bomani Committee, Pokora Committee, and other committees, now could be the reason that necessitated the amendments. Now, when the amendment was done, the cancellation of the retention license was the result of the amendment. That's what I stated. Thank you.
Any questions from council arising from questions of the tribunal?
No, Madam President, thank you.
Mr. Mandepo?
None.
No. Good. Then that ends your examination, Mr. Genge. Many thanks for your explanations.
Thank you, Madam President.
And I think that is a good time for the lunch break. Let us be back at 1:30. Have a good lunch.